Hello, everybody, and welcome to this month's Specify and Practice Community Session. Dave and Lewis, over to you.
Well, thank you very much, Matt. This is Dave coming to you today on the road again. I'm torturing Lewis, except that he doesn't have to drive today. We're going to leave that to our guest host, Josh. And Lewis, I'll turn that over to you to introduce yourself and Josh as well.
Okay, and for those of you who are watching, I'm the guy in the middle with the beard and the Hawaiian shirt. Off to the west is Josh Flowers in Memphis. Josh is the only registered architect and licensed attorney in the state of Tennessee. He's also a CCS and a CCCA. The man just likes to take tests. But Josh and I work together at what used to be Nidec Boba Group, is now HBG Design, and he is general counsel. And so David and I were able to persuade him to help us out with this session, which has been requested by a number of different people, and there have been a fairly recent, a couple of different discussion threads on the forspecs.com forum. And so without further ado, I'm going to turn it over to Josh, and at the end of the hour, we're also going to let Josh tell you a little bit about the presentation that he's going to be making at Construct 2017. So, Josh?
Great. Well, thank you, Lewis and David, for inviting me to participate in this conversation on a very important topic that affects all of us. So we're talking about intellectual property, and we're looking at it from the perspective specifically of design professionals. So looking at the design and construction industry and how intellectual property affects the process that we use. But before we get into some of the specifics, I thought it would be good if we take a step back to ask about why is this such an important topic, especially now. And so I wanted to share this image. On the right, you can see the contractual roles, and I think we are very familiar with this tripartite relationship where the solid lines indicate contracts between the different parties. So we have an owner who is doing a project and has hired someone to complete design, a company to complete construction, and then various consultants and subcontractors and trades that are associated with each of those. So I don't think that that is anything that is very new or unusual. But on the left, you can see a diagram of an actual project and how the parties actually communicate with each other during design and construction. So you see the design team and the construction team, and then all of these different arrows and different lines indicating the ways that they are interfacing. And I use this to illustrate the fact that no surprise to any of us, design and construction has become very complex, and the way that we are talking about our work is also very complex. So the intellectual property issues have become even more important than they may have been in the past, because we're asking the question, what is the information, first of all, that we're sharing? And then secondly, how are we sharing that? And then the third question is, who are the recipients of the information once we have determined that that is going to be shared? So I think this is a good illustration because it shows, on the one hand, a contractual relationship that appears to be somewhat straightforward, and then in actual practice, something that is entirely more complicated than the contracts may reflect. And I think that's where some of this ambiguity comes in. And as practitioners, we are the ones left to fill in the gaps and make sure that the project is proceeding efficiently. So to help us do that, that's why we are delving deeper into some of these intellectual property issues. So here is a definition. What do we mean by intellectual property? We're talking about anything that it's an asset, meaning that it's owned by a party or more than one party. One example is a copyright. That is the most common type of intellectual property that we deal with, particularly in design, but there are actually 3 types, and we'll look at all of them a little bit later. But some of the common examples that we see and that we work with all the time, early in the project, there will be design representations. So depending on the level of completion, there may be intellectual property associated with things as they are created. But certainly by the time you get to the construction documents phase and have fairly complete documents, some type of intellectual property has been created. And then there is a question about who the owner is. And so we'll be taking a look at some of the contract terms that help to sort that out. Some other things that we work with, software is protected by intellectual property, sometimes owned by the software provider. So if you're using an Autodesk product to create design documents, the tools that you're working with may be patented, may be owned by a company, and you have a license to use that. And the product that you're creating, although you're using software that's owned by someone else, your work product may be owned by you or a third party. A lot of logos may be subject to trademark, so the way you share your corporate representation, if there is a trademark, a lot of times those types of logos, and in particular if they appear on the title block, there may be intellectual property associated with those. And then when we get into the construction phase, we come across some other types of intellectual property when we're dealing with those types of unusual construction applications. In some instances, those may be patented, and it's very important, especially for the specifiers, to understand if something is going to be included in the contract documents that is subject to intellectual property of someone other than the design team. Another thing that may show up is those types of custom applications. Sometimes you will see techniques that have been patented. So these are some of the things as we walk through a project lifecycle, ways that intellectual property is present throughout that process.
Say, Josh, I'd just like to ask, you mentioned something about creating content. So is the intellectual property right tied to something being unique or something new that has not been done before?
Yes, and that is always the question, is when does the copyright come into existence? And especially with design, if you look at some of the cases where designers are creating something of value from the moment that they begin any type of participation. But the question is, are they just sharing ideas, or have they gone further and committed something that meets the definition under the copyright statutes? So we'll look a little bit later into some of the specifics about how that comes up. But certainly that is the important question that we need to keep in mind. Whenever we're doing work, we are creating that value, and you want to make sure that it's kind of raising a flag that when you're creating value, you want to make sure that the rights and responsibilities are documented in writing as to how these property rights are going to be assigned. So I just say that to make us aware. We're headed into more discussion of the contracts as we go through this discussion, but that really is the underlying issue for all of this. So why don't we take a look at these three types of intellectual property in a little bit more detail. We talked about trademarks, and the thing about trademarks is it has to be something that is very distinct. So you think about the corporate logos, the corporate identities that you're very familiar with. What are the characteristics of that? It's something that at a quick glance, it communicates the identity and is very distinct from anything else. So the question with trademarks is it too similar to something else for it to carry any type of intellectual property rights? But these types of names, the names of a company, the names of a product, a symbol like a logo, and even sometimes distinct sound or color, think about artistic representations, all of those things could be subject to trademark, but the challenge with that is to find something that is distinct from everything else that has been created. So when you're, especially if you have been through the process of trying to create a new logo or something like that, you think that you've come up with a unique concept, and then you find all of these things out there that are too similar, and that's where you go back and refine. But not as common to the design process, because we're looking at those very distinct things, and as David alluded to, what makes something really distinct, and sometimes with design it is its own type of process. The second thing are patents, and we mentioned that in particular with regard to construction processes, but these are things that are more of an invention. So something that someone has invented, it could be a process, it could be a product, but something that is more complicated perhaps than a trademark, but it's something that someone has created, or an invention that comes from someone's thought process. So sometimes we see that there are BIM tools that have been patented. Autodesk has a lot of patents. Any type of software company usually has patented many of the different aspects of the things that you are working with. And then the third thing, which is the most common that we work with, is copyrights. So for architects, we have the Architectural Works Copyright Protection Act, which gets into a lot of the specifics about how the copyrights attach to our work. So we'll want to look into more detail about how that affects the work. But it does include the design records, for one thing, but it also includes the building itself, subject to some limitations, which we will explore. So these are the three types, and it's good to keep those in mind, but in particular to focus on copyrights. So here's the slide to deal with ownership, and I think we've already started talking about this a little bit through some of the questions. But here's the issue with copyright ownership. There could be one author, but there can also be multiple authors. So it doesn't necessarily mean that one person owns the copyright, but it's always subject to contract terms. So you may,
Josh, I have a question, and maybe you're going to deal with it a little bit later. A lot of owners, a lot of our clients want to own the contract documents at the end of that are produced for the project. When they do that, that ownership of the documents, is that separate from the copyright ownership, or are they inextricably mixed, connected?
So it's a very important question, and I think when you start getting into that discussion, the important ground rule to keep in mind is particularly for design professionals to make the distinction that you are providing services for a fee as opposed to selling a product, because that is very different under copyright laws and also under the negligence cases and other liability issues. So is an important thing to sort out first. And a lot of times when we see that being intermingled, you're getting into more of question of the owner thinking that they are buying a product, buying the documents themselves, when really the design professional is providing services. And then that's where we have that term, the instruments of that service is the documents. So
I often say that an example of that is when you go to the doctor and he writes you a prescription, you may own that piece of paper, but it's really an instrument of service. You can't change it legally because he's prescribing something that is a legally controlled substance, but it is an instrument of service.
That's right. And I like that example because, a lot of times with the contract language, one of the questions is, can someone else take those documents and then complete the project without the participation of the design professional? And if you think of the analogy of a prescription, one person has that, and you can't give your prescription to someone else and let them use it. So that's one of the other questions that we sometimes get into is what type of use is approved for these contract documents.
And then the other thing to keep in mind about copyrights that I've read before is that you can't copyright a generalized idea. You can only copyright a specific expression of an idea.
Right. And that comes from the copyright statutes. We now have specific statutes that describe for architectural work what is subject to copyright. And like Lewis was saying, just an idea is not enough to warrant copyright protection. It has to be more defined. It doesn't get into the specifics, but if you think about the project phases, something created during the concept phase would be less likely to have copyright protection than the contract documents at some level of completion. So that's another important thing to keep in mind. Some of the other terms that we'll see, there's work for hire, which we'll go into a little bit more in detail because I know some people have seen that popping up in agreements. And what does that mean? There is the idea of a derivative work. And then we get into what's also the derivative of a derivative. So this is talking about you create something that is original and then others may use it. So there may be photographs, there may be other formats using imagery and other things that are coming from something that's owned under a copyright, but then it's being used as part of a greater work. So that's where we get into these derivatives. But then if the underlying work is owned under the copyright, then it must be addressed even in its derivative form. So that's where we get into questions about the transfer of rights. And that also gets back to the question that David was asking in the beginning about when do these copyright when do they start to come into existence? So we talked about work for hire, that could happen before or after the work is created, but we are dealing with property, so it can be sold, it can be assigned under contracts, and there can also be a license where someone owns the copyright, but they have given a license to someone else. And so then the question is, what does the license say? And that should be defined in the contract.
We have a comment from Chuck Coleman, Josh, who says, his office, offers joint ownership of the drawings, but maintain intellectual property rights of the design. Not as easy to do, though, with work in the public sector.
Right. So that is a good way sometimes to address it, because you want to have some way to use the design in the future. It's very important, especially for architects. A lot of the value that you provide is part of that design. So that can be a way to address it. And there, we'll look at the way that it's defined in the AIA agreements as a baseline. And but that certainly is a way to have those rights assigned, but still retain the value that the architect has provided. So let's look at some specifics. When we're talking about copyright, what does it include if we're talking about an architectural work? So that question kind of leads into this. An architect has a copyright to the overall form of the building. So if you're looking at the building from the street, the form of that building is probably subject to copyright. Things like the arrangement of spaces, the layout, the plan, the particular configuration that is unique to that project is subject to a copyright. And those unique design elements are subject to copyright. You know, we haven't always had the Copyright Act, but before that, in the earlier days of design, very unique ornament would be something that was not subject to copyright. So architects may have been creating ornament for a building facade, but it was not protected by copyright, whereas other artistic works were protected. And that was one of the reasons that the Copyright Act was brought up, is to address some of these issues. And of course, now we don't deal as much with ornament, but that is one of the things. So what are those unique design elements in contemporary projects? Those would most likely be subject to the ownership of that copyright. But the last one on this list, the copyright includes a right to keep the owner from using those documents to complete construction, but that's subject to the terms of the agreement. So you may have a right to prohibit the owner from using those documents. For instance, if there is a failure to make payment, that is one of the common reasons to exercise this right. But it also is possible to give it away, and so the owner can complete the project without making payment. So we'll want to look at some of the contract terms that deal with that.
So, Josh, I have one more question. This might be a little bit out of bounds, but if the architects are creating a building form that would invest in a copyright, and an architectural photographer takes a photo of the building and also places copyright on that photo, is that some sort of competing problem here?
Yes, and thank you for that question. So let's go ahead and see what is not included is the next slide. So a copyright does not include, and we'll go ahead and skip down to the second one. So you do not have, even though you have created the unique building form, that does not include a right to prohibit photographs of portions of the building that are visible to the public. So if you are taking a photograph of a building that you see, that does not mean that the person who has a copyright to that design can prohibit you from taking that photograph, or does not mean that they have any rights to the photograph itself. So that is not considered to be a derivative work because buildings are so public. But there may be interior portions or other things that are not visible to the public. So we see things in the AIA agreements that talk about, you know, even if the owner did own the copyright, the architect may still have rights to photograph the project for its own purposes. But that is one of the questions that does come up if the building is public, then others have a right to take pictures of it. And you think about how often architecture shows up in representations, in images. Think about city skylines, all of the works of architecture that you may see in a photograph. That is one of the reasons that it can't be or is not included in those elements that are protected under the copyright.
But along that same line then, is it appropriate that the photographer give credit to the architect, or is that required?
Yes, it is appropriate. You know, one of the issues is that a photograph that is particularly focused on a distinct work, in which case you're getting into more of attribution questions. But if you're, you know, taking a photograph of a person and a building happens to be in the background, you know, it gets into more of what is the focus. Is the work of architecture incidental to a different work of art or copyright, or is it more, is the building itself the focus, in which case, in most instances, the architect should receive credit as the person who created the unique form. A couple of other things that are not included: standard elements. So standard details, standard provisions, if you're talking about the specifications. Some of those things may not be subject to copyright. And this is something that we get into that becomes a little bit of a double-edged sword. On the one hand, you know, as a couple of people have already mentioned, the owner may want a copyright to the design. So they may get a copyright to those unique features, but that does not include standard features. So standard things that are used repeatedly on multiple projects, you know, office standards, things that you would use on any project that you work on, may not be subject to copyright because they are so common and difficult to distinguish from one work to the next. A couple of particulars from the statutes. There are time limits on copyrights. So if you are a sole practitioner, your copyright exists for your lifetime, now plus 70 years. It used to be 50 years and has been extended under the revised statute. It's different, though, if you are a corporation or a company. You still have intellectual property rights, but it's treated differently from an individual. So the statute says that those rights would be 95 years from the date of the first publication, or 120 years from the time that the work was created. A couple of other things that are not subject to copyright, and this is something that David had referred to earlier. If it's just an idea, it hasn't really been defined, a concept very early. There are some cases where, you know, an architect is hired to design a hospital, and they, you know, provide some renderings, some concept drawings, but then the owner determines that they are going to hire a different architect. And in one of the cases, you know, the hospital was then built and looked very much like what the initial architect had shared in their renderings. They brought a lawsuit to try to protect their copyright, but the court determined that at that very early stage, it was still just an idea. It was not yet a work subject to copyright. So that's where you think about the project phases. The further along that you get, the more likely that you have created something subject to a copyright. And then if you're looking at,
Josh, on the other hand, even though the design might not be copyrighted, if there was a rendering that was drawn, the owner might not be able to use that because the rendering itself would be kind of a separate copy, would be copyrighted.
Right. And some of these court cases are now a little bit dated as to how we now work. If you think about, a schematic set is now very advanced from what it used to be. Renderings that are provided even at the early stages may appear to be very photorealistic. So I think that we're now getting into more, as we try to shift that McLeany curve that a lot of us have seen back into the earlier stages of the project, doing more work earlier may mean that we are now creating those copyrights earlier in the project than people may have previously when some of these cases were decided, which is very important as we think about the shift in practice. And then one other thing, if you're working outside of the United States, all of these copyright statutes are, the U.S. statutes. So in different countries, there is what's known as the Berne Convention, which some countries have signed on to. But if you're working in other countries, it's important to identify what rights do you have to intellectual property. A lot of architects who are working in China have had concerns about a lack of intellectual property protection. So it's something that you have to deal with in the very early stages if you're proposing for work outside the United States. So we talked about licensing and said if we own the copyright, then we can retain that ownership, but give someone a license to use our work in some way. And if we have a license, it needs to be defined. So you can authorize that use of the intellectual property, and then you can have restrictions, and that is what we see in a lot of the standard agreements, is that the architect keeps a license, but there are ways that others who need to use the documents, for instance, can use it in a defined manner. But you should also have provisions that address unauthorized use. So if there is something that is not approved, that it's dealt with through the contract language. There can be an exclusive license, which means that there is a single entity who holds the license. There's also what's known as the non-exclusive license, meaning that there is still that single entity, but there may be others who share in some type of rights.
Like subcontractors.
Right. So you think about all of the people who have to use construction documents. There may be a permit official who needs to receive it. There may be in the bidding phase, right, multiple prospective bidders and others who would have to have a means of reproducing and sharing with people, for instance, in preparing bids. So that's where we get into it's not exclusive to any one person, but then once someone is selected, then it may become more of an exclusive license, subject to the contract terms. I wanted to go back. We had mentioned work made for hire, but I know that some people have seen this, and I wanted to give a little bit more explanation about what we're talking about. This is, if you're doing work for your employer and you are the employee, the work that you create is known as work made for hire, meaning that even as you are creating it, it is owned by the employer. And I think that's familiar to most of us. We work for a company. We are not creating the work for use for ourselves necessarily, but it's part of our employment. So the question comes up if you are doing contract work, either as a contract worker or under a contract as an independent contractor, then you have to get into a series of tests to determine if this is work made for hire, meaning the employer or the owner is automatically receiving ownership of your work. Some of the factors, it has to be something that was what's known as specially commissioned, meaning that the owner must have asked for this and have some definition of what the commission encompasses. And then it has to be for a purpose that is contained in the statutes. If it's not subject to intellectual property rules, then it's obviously not going to fall under this definition. And then the contract must specifically state that it is work made for hire. So this is kind of, using the magic words. If you don't use the words, then sometimes you would lose those rights. And that's why in a lot of contracts, you will see this term work made for hire, and it sometimes is an indication that the owner is trying to obtain ownership of these intellectual property rights from the design professional. So that is a little more insight into why we're seeing that show up in agreements. So let's briefly look at some of the contract terms. Here is the provision from the most recent version of the B101, and you can see what we're looking for is this language. The architect and the architect's consultants shall be deemed the authors and owners of the respective instruments of service. So this is saying that we're establishing that authorship, which we said, a copyright has to be a work that is created. So this is contractually establishing that foundation for the ownership of the copyright by the architect and by the architect's consultants. So we have multiple people on the design team, all considered the authors of their work under this contract.
And Josh, and those consultants may include people, entities that are not registrants. For example, a food service equipment consultant, a medical equipment consultant, an elevator consultant, and perhaps even a specifications consultant.
Right. And keep in mind, copyrights don't necessarily have to correspond with the licensing laws. So you may be creating work of value, and whether that is subject to other licensing regulations does not necessarily create any conflicts for your intellectual property rights.
And Tommy Smith had a question along those lines. I think you just answered it.
Oh, okay, great. I wanted to look, here's the other provision from the new B101, very similar to what we've seen before, but this is now talking about the license. So we had said that obviously these documents have to be shared with multiple parties. So we want a way to retain that copyright but still give the license. So this is stating how that works, that it is a non-exclusive license. And as Lewis alluded to, you think about all of the subcontractors and others who have to receive these documents. It has to be a non-exclusive license, but exclusively for the purpose of constructing and dealing with the project. So these works are only for the project for which they were created. And that is a concern if you see, a building pop up after you've completed a project that looks just like what you designed, but you had no involvement. That is a breach of this provision, that it is only for this project. So this is the important language. When you're dealing with a license, you want to think about all of the possible ways that the license could be misused and make sure that the contract addresses the scope of the license. So another AI document that is becoming more important and is now referenced in the AI owner-architect agreements is the E203, which is the BIM and digital data exhibit. So think back to that initial image that we looked at. Anytime that we're sharing work, especially in a digital format, meaning that it is easily modified by the recipient, it's very important to talk about what is the appropriate means of transmission, what is the appropriate use, and that is why these digital data sharing documents can become complex very quickly, because you're dealing with multiple types of use, multiple parties, all interconnected. So trying to define that can be challenging, but it's also something that is important to deal with. So some of these will say, if you look at 2.1, the transmission of the data includes now a warranty by the party who is transmitting that they are the copyright owner. So some of this gets into people sharing documents without rights, and you want to make sure that someone isn't introducing something into the project that they did not have rights to in the first place. So this says that if you're sharing something that you warrant, that you have the right to do so. And then a couple of other things from the digital data exhibit will say that just because you're sharing something does not mean that you are transferring any of your intellectual property rights. So that is important.
Especially if you're sharing a live file that can be modified or used by the recipient for something that, for example, to do the ductwork shop drawings from the BIM model does not mean that you're giving up the copyright to the original files and documents for the design.
Exactly. And I know that one of the questions that has come up, I've heard a lot of conversations at recent conferences about how much longer will we actually be using drawings? Will the model be the deliverable? And will that be what is used going forward at some point in the future? So one of the issues is that the model in that digital format, like Lewis said, is subject to change. So if people are modifying that, who is the owner of those modifications and who is authorized to make those changes? All of that has to be defined the more that we are relying on the model. So it's a very important question, and it's something that is somewhat fluid right now in terms of the industry, but something that we have to address through the documents. So I bring this up. This is how we are now dealing with it. But the thing to keep in mind is that you don't want to share information in digital format without defining in writing what the appropriate use is. So keep that in mind if you're asked to share any type of native format digital information. There should be an underlying document before you transmit the data.
Josh, just one question on this. Because E203, as I understand it, is a document that's meant to accompany the owner-architect agreement or the owner-contractor agreement. Is this also something being used between, say, architect and architect's consultants?
The way that it's dealt with, it should also address sharing the consultant's documents. So you want to make sure, from the owner's perspective, everyone on the design team should be using the same digital data sharing protocol. So there shouldn't be any difference between any one entity on the design team, at least from the owner's perspective. So it's important, if you are the prime design professional, that you make sure that all of the consultants have whatever the protocol is and that it is included in consultant agreements. Otherwise, there could be that disconnect. So it really is important to make sure that all of the design participants are coordinated, and that is the responsibility of the prime design professional.
We have a couple of questions, Josh. Louise Schlatter asks, what about the modified BIM file once we get it to a contractor or subcontractor? Who owns those the modified file?
So the question would be, who modified it? Is it modified by the design professional before they share it, or are they sharing it and then the contractor is carrying forward with changes through their subs, through others on the contractor side? In that instance, the architect would own the underlying rights to the model itself. And in most instances, the intent is that the contractor is not necessarily changing the underlying model from a design standpoint. They are carrying it forward to further levels of development, but in keeping with the original design intent. So if they're making changes that are contrary to the design intent, then it should be submitted through the contractual change process so that the architect approves it. But the contractor would not necessarily be creating something that would generate new rights, if that makes sense. So the contractor is...
Would the subcontractor, for example, who bases its shop drawings for ductwork, since we used that example previously, they would have some ownership of that revised or that document that is produced from the base drawing, base BIM provided to them by the AE firm.
Mm-hmm. So, and then sometimes when you're talking about that, then you're getting back to, especially if you're talking about shop drawings where you're getting into very high level of development, talking about how something is actually going to be fabricated or constructed, then are you getting more into something that is so general, so repetitive, and used on multiple projects that it may not be subject to a copyright because it is not distinct. So some of those things, because they may be used so frequently, sometimes it's getting into more of that, it's more of a standard than something that is distinct and subject to copyright. But certainly something that is created at that level, there may be intellectual property rights that are generated by the fabricator, by the shop drawing preparer, that you will need to be aware of.
Okay, Josh, we have a couple of questions that have popped in. I'd like to ask you one from Paul DeArmont. He says, can an author assert a copyright but simultaneously deny liability for errors within the content of the copyrighted material?
Well, yes. The copyright, like we said, the copyright applies to the building form. It applies to, some specific unique aspects of the project. But when you're talking about liability, you're talking more about negligence and what is that standard of care. A lot of times errors and omissions, would a similar architect have included something where it's omitted from the case that you're looking at. So it is possible to hold that copyright, but still not have liability if it exceeds the standard of care. So you're really talking about those two different questions. So you can still retain the copyright and then get into the separate conversation about liability.
Okay. There was another one from Gail Ann Goldstead who says, talking about the word employer, and this, I think, in terms of work for hire. In some parts of the world, the owner refers to themselves as employer. And I think we see that whenever the contract is operating under a FIDIC set of conditions and agreements. So she's asking if there's some clarification that you could make on that point.
Well, actually, we ran into this from time to time back when I was working with Josh at HBG, is that we would get contracts in which from various that were not standard form AIA or other standard form contracts. And one of the things that the lawyer written documents were always very careful to do is to clarify that the architectural firm was not an employer, was a consultant, and definitely not an employee of whoever was the client was. So that is an important concept.
Right.
A lot of times what you'll see, I would look in the document somewhere, is there a provision that defines an independent contractor relationship, a lot of times that is the important thing. And from the owner's perspective, the reason they don't want to be classified as the employer is that means that they owe payroll taxes, they may owe employee benefits and other things if the person is determined to actually be an employee. So you're getting into Department of Labor and some other issues that you'll need to be aware of. So look for that independent contractor provision and see if it provides more guidance in the particular circumstance. Very quickly, we still have a couple more minutes. I wanted to share a couple of things. You know, we've looked at the standards, we've looked at the statutes, but how do we see this coming back to us in terms of actual projects? And it's a lot of times through these owner-drafted agreements. So here's an example of one. This is how it looked when I first saw it, a proposed agreement for architectural services. And here are some of the things that, you know, raise the red flags. Skipping over a lot of this language, you know, first of all, very long provision compared to what we saw earlier. But all design documents shall be the property of the owner. So that is what Lewis had mentioned earlier, you know, trying to obtain ownership and then look at all of this definition of things they're trying to include, very general things like artwork and concepts, and then very specific things, and trying to include everything under that ownership. And then it goes on.
And most owners have no idea that would mean they would have dozens of banker boxes full of stuff at the end of a job. If they really got all that stuff, it's a bit ridiculous.
Right. So you think about the design process and everything that is generated, iterative examples, right?
All the bumwad paper, a little phone notes and messages and things like that.
Right. So here it goes on, and here we see our phrase "work made for hire," and it also raises that red flag. But then trying to get to this instance of it immediately upon creation becomes the property of the owner. So that is what we're getting at, is that as soon as it's created, that it becomes the property of the owner. So what is the issue there? Has the design professional received payment at that time? That is an issue that needs to be resolved because you should have a way to receive payment if you are going to agree to assign any type of ownership rights. So it looks like we have a minute. I just wanted to summarize some of the things that we're looking for. Anytime we're dealing with intellectual property, we want to make sure that we have contract terms that define specifically how this is addressed, that take into account the particulars of this project. It is good to provide a license, not necessarily ownership of the copyright or the documents, that provides for that reasonable use by subcontractors, permit officials, and others to construct the project, but not beyond, and that should be defined in the license provisions. We want to avoid agreeing to transfer ownership, especially without even receiving payment. And we want to make sure that we don't agree to any kind of uninsurable indemnity dealing with intellectual property. Someone asked about liability earlier. Sometimes it can come up, but we want to make sure that we don't sign off on something in an agreement that would say that. And then when we're transferring data, especially if it's in that digital format that can be manipulated, do not transfer it until you have those written terms signed off on that provide for the appropriate use. So that is kind of an overview.
We did have on that last bullet point, we did have a question earlier, which we didn't quite get to. Is there a difference between a digital document and digital data?
It can be different terminology. You know, a document usually refers to something that is in a distinct format, and then data may include multiple documents. So usually we're talking about the same thing. We may just be getting more focused on a particular document where data is more inclusive of multiple documents in most instances. But be careful and look for, are the terms defined in terms of a protocol where it would be defined in your particular agreement.
I think one example would be transferring the BIM files is different from transferring AutoCAD files, because AutoCAD files are for specific drawings as such, but the BIM is really a database that's got information in there that may or may not be exported into two-dimensional drawings.
That's right.
Well, terrific presentation, Josh. You made things a lot clearer to me than I've previously understood them. Why don't you tell folks a little bit about the presentation that you're going to do at Construct 2017? I've already signed up for it, and we'll see if we can get some more people to do so.
Well, I'll be in Providence for the Construct conference this year and doing a session on Friday about the standard of care. So we'll be looking at some of these issues from the perspective of liability and taking that step back to look at the bigger picture about what is the standard of care, and in particular, how is it changing with all of the advancement of practice that we're seeing. So hopefully we'll see some of you there.
Well, thanks very much, Josh. Really appreciated you agreeing to join us today, especially since we had several folks ask for this presentation. So we hope it met their expectations. We hope that we hear more suggestions from them too as we go forward. And you know, maybe there will be another opportunity after Construct to invite you back again.
I look forward to it. Thank you for having me. Thanks for everyone's questions. This is great.
So, Louis, what have you planned for next month?
Nah, you beat me to the punch. I was just going to ask you, oh nefarious and slippery person.
Nefarious and slippery.
Yes,
wow.
We have
okay,
a nefarious laugh.
Okay, so we are going to have to get our heads together, and hopefully we have some of the folks that are online today even submit some more suggestions. We love to hear from you. We want to know what it is that you want to talk about, and because we want to make this program enjoyable and entertaining and informative for everyone that dials in. So let us know what you would like. Next month we're back again on September 7th. Just before the holiday and just before Construct. So you're going to have to wait until October anyhow to get to some sort of a Construct recap. So September 7th, 3 o'clock Eastern, we'll be right here again waiting for you to dial in and join us.
And I'm sure David is going to come up with a whiz bang of an idea.
We'll see what we can do. Thanks so much, everyone.